Hey, Melissa Wick here. I own Wick Law Offices, a law firm in Columbus, Ohio. Today we're talking about what to do if you get served with a complaint or a lawsuit. So, a couple things. I know getting served with a complaint would be extremely stressful. So, the first thing I'm going to tell you to do is don't you dare try to do it yourself on this. The best thing to do is to schedule a consult with a lawyer immediately. So, that's step number one. Schedule a consult with a seasoned litigator. And I'll tell you that litigators come in all varieties, right? Like there are divorce litigators, there are discrimination litigators, there are civil rights litigators, there are criminal defense litigators, and there are people who specialize in breach of contract litigation and in the business context. So what I'm going to suggest to you is to do a little research and find a lawyer who specializes in the area that you need help in. So if it's a business case, which might likely be like a breach of contract situation, you need to find a litigator who does that type of work and has done that type of work. So you might want to ask them, have you done a jury trial? Do you settle cases or do you try cases? What kinds of cases do you typically handle? Then the second thing I want to explain to you is that some lawyers do free consults, and some don't, and that's fine. I'm not saying a free consult is better even, but what I'm saying is if you're going to be charged for a consult, you should ask that lawyer to take a look at your complaint ahead of time and maybe send them a list of questions that you have for them ahead of time, because what you don't want to do is pay a lawyer to have a consult and then get very generalized legal advice. So, the way I do it, I offer free consults, but also I will do a paid consult if somebody's asking me to take a look at their complaint and do some analysis so that I can give them more pointed advice. So if someone wants to charge you for a consult, I would just ask, well, can you take a look at my particular situation prior to our consult so that the advice would be more relevant to your particular situation. So my first step in what to do if you get served with a lawsuit is to call a lawyer. The second thing to do is examine preliminary matters. So when you're sued, there's a couple things that need to happen. So the first thing is you want to ask, did service happen the right way? So to get served properly with a lawsuit, it doesn't mean that you just hear about it or the plaintiff themselves has handed you the complaint. It has to be served usually via certified mail and sent to the statutory agent of your business. So also sometimes lawsuits get served by process server. That's called personal service. So if you haven't been served in one of those two ways, personal service or via certified mail, then service may not have even happened properly, and that's really important. So you want to double check that service actually happened the right way. And then aside from that, you want to double check that there's jurisdiction for the case. And not to get too detailed, but what that means is that the case is brought in the right forum. So is there subject matter jurisdiction? Is the venue the correct place? Is this the correct place to sue you? So you can't be sued in a jurisdiction where the incident didn't happen or where you're not doing business. So you want to make sure that those things are correct. Jurisdiction's proper and venue's proper. And then another thing you can ask a lawyer to look at is whether or not there's any motions that can be filed before the case even gets started. One motion in particular is called motion for judgment on the pleadings. And this motion it's kind of reserved for a situation where the plaintiff has just brought a case that really has no merit whatsoever. So it's really tough to prevail on a motion for judgment on the pleadings, but if there's any chance that the court might see that this lawsuit is just so far removed from reality and should never have been filed in the first place, you should at least ask the attorney you speak to, is there any option for a motion for judgment on the pleadings? Because what that would do is it would stop the lawsuit really before it even got started. So that's another option that you should at least just talk to your lawyer about. Step 3 would be to prepare responsive pleadings. So a responsive pleading, when you're the defendant in a lawsuit, the first responsive pleading is generally called an answer. And an answer has to be filed 28 days after you were served with the original complaint. So you've got 28 days to decide if you're going to hire a lawyer, to find that lawyer, do a few consults, figure out who you like, and then in that time, the answer needs to be filed. So what you don't want to do is hire a lawyer with a day or two left before that 28 day time frame, because that's going to rush your lawyer. It's probably going to result in higher fees to you. So what you want to do is give your lawyer a long runway to analyze your situation, take a look at your complaint, analyze whether or not there's any affirmative defenses that need to be brought, whether or not there's any motions that should be filed prior to filing an answer, and just give you and your attorney plenty of time to communicate about the facts. The facts are what drives these cases, so the longer you have to analyze facts with your lawyer, the better situation you're going to be in. And when you're preparing responsive pleadings, you want to have your lawyer analyze any affirmative defenses. So affirmative defenses go in the answer to the lawsuit. So affirmative defenses are things like failure to state a claim upon which relief can be granted, or equitable claims like estoppel or waiver, or maybe your lawyer might say that there's not even a contract that governs the dispute. There's various different affirmative defenses, but those are a really important part of litigation. So you want to make sure that you speak to your lawyer about what affirmative defenses are you going to bring on my behalf in this case. And then also you want to talk to your lawyer about, are we filing a counterclaim? So along with the answer is also the opportunity for the defendant to assert any claims that the defendant has against the plaintiff. So I'll tell you what's really common in a breach of contract case is that maybe the person you're in a contract with feels that there was a breach, and so they stop paying you. Maybe you've done work and they've just withheld payment because they don't like the work or there's a disagreement about the work. So generally, I find in these cases, the defendant in the case has a cause of action as well, and it usually involves somebody withholding payment. So when I handle these cases, I usually examine whether or not we need to file a counterclaim on the defendant's behalf, and almost always the answer is yes. So that's another thing that you ought to talk to your lawyer about, to see whether or not there's going to be a counterclaim filed and what affirmative defenses will be brought in the case. Step 4 involves planning how you're going to handle your emotions as you go through the process of litigation. I'll tell you, litigation is a huge slog. Sometimes it takes 2 to 3 years to finish a case. So what you need to do from the very jump is to figure out how you want to show up for yourself while you're going through this litigation. No matter what, it's going to be stressful, but there are some things you can do to make the stress less on you. So you don't want to have unnecessary overwhelm and anxiety about something that is largely beyond your control. So that's just one thing I would suggest, is to decide ahead of time how you want to show up and try to do some work on managing the thoughts you're having about the whole lawsuit so that you don't make it harder on yourself than it already is. So again, my name is Melissa Wick. I own a law firm here in Columbus, Ohio, and I represent small business owners in all areas of their business. Thanks for watching.